Lately, you may have seen headlines, videos, or social media posts claiming that family-based immigration is about to end, or that family sponsorship will stop in 2026. Some even go as far as saying that President Trump is planning to completely shut down family petitions, starting as early as 2026. If you're sponsoring a loved one, waiting on an I-130, or planning a family-based green card, it's completely normal to feel anxious, confused, or even scared when you hear things like that. Let's clear something up right away. There is no new law that has taken effect. There is no sudden rule that has stopped family-based green cards. There is no official policy that has quietly eliminated the I-130 petition process. What you're seeing online, viral posts, heated opinion pieces, political commentary, and recycled clips, is usually a mix of speculation, old proposals, and political rhetoric, not actual changes to U.S. immigration law. The good news is you are not alone, and the truth is still very straightforward once you separate facts from fear. In this video, we're going to walk through what is really being discussed. What, if anything, has actually changed? And most importantly, what it all means for you right now, especially if you're filing, waiting on, or planning to file an I-130 for a family member. Stay with us because by the end of this video, you'll have the facts, context, and peace of mind you need. What is the I-130 and why is it so important? Let's start at the center of all this. The Form I-130, Petition for Alien Relative. This is the form that U.S. citizens and lawful permanent residents, green card holders, file with USCIS to begin the process of sponsoring certain family members for a green card. It's the first step for spouses, children, parents, and in some cases siblings to start their path toward becoming lawful permanent residents of the United States. For decades, this has been one of the core pillars of U.S. immigration and one of the most common ways people come to live and work here legally. Not through a job offer, not through asylum, but through family ties. That's exactly why any rumor about ending I-130 or ending family sponsorship gets so much attention. Because it touches the very heart of family reunification in U.S. immigration law. Where are these rumors coming from? A lot of the current fear comes from discussions and proposals circulating in certain political and media spaces. And it's important to emphasize that word, discussions. Some of these ideas are connected to commentators and policymakers who supported former President Donald Trump, or people who favor similar policy positions. As we move closer to major election years, especially around 2024 and beyond, you may see think tanks, opinion writers, and some media outlets bringing back old proposals from 2017-2021 during Trump's first term. These discussions include ideas like changing which family members count as immediate relatives, reducing or eliminating some family preference categories, shifting the system to favor skills-based or employment-based immigration over family reunification. But here's the critical point. These are ideas and proposals, not current law. None of these proposals have been passed by Congress. None of them are active USCIS policy. None will automatically kick in on January 1st, 2026 or any other date without going through the full legal process. So let's talk about that process because understanding it will help you filter out a lot of noise. How immigration law is actually changed. In the United States, immigration law is created by Congress. That's the legislative branch. The president and the executive branch, including USCIS and DHS, are responsible for enforcing those laws. They can issue regulations, set policies, release guidance on how laws are interpreted, but they cannot, on their own, just erase entire legal categories like family-based immigration. For something as big as ending the ability of U.S. citizens to sponsor their parents or siblings, or removing entire family preference categories, you would need new legislation to pass. The House of Representatives, the Senate, and then be signed by the President. That is a high bar. It requires debate, public attention, votes, and broad enough political support to make it through both chambers. As of the most recent information available, there is no law introduced and passed that ends or fundamentally restructures the family-based immigration system. There is no bill that has successfully moved through Congress to eliminate I-130 or shut down family sponsorship. So when you see headlines like Trump to end family immigration in 2026, I-130 petitions will be suspended, you must ask, is this an actual law? Is it a final regulation? Is it an official USCIS policy memo? Or is it a campaign idea, a political opinion, or a proposal that hasn't gone anywhere? In almost every case currently making the rounds, the answer is not a law, not a regulation, not in effect. What does the law actually allow right now? Let's look at what the law really says today about family-based immigration. U.S. immigration law currently provides several family-based categories for green cards. 1. Immediate relatives of U.S. citizens. These are called immediate relatives, and they include spouses of U.S. citizens, unmarried children under 21 of U.S. citizens, parents of U.S. citizens who are 21 or older. For these categories, there is no annual numerical limit on how many green cards can be issued. That means there are no visa quotas that create years-long waits just because of numbers. Processing times can still vary, but there is no category cap backlog. For immediate relatives, the I-130 process is often more straightforward than in other categories, though it still involves background checks forms, supporting documents, and usually an interview. 2. Family preference categories. Then we have the family preference categories, which do have annual limits. These include F1, unmarried adult sons and daughters of U.S. citizens. F2A, spouses and unmarried children of lawful permanent residents. F2B, unmarried sons and daughters, 21 or older, of permanent residents. F3, married sons and daughters of U.S. citizens. AIC, brothers and sisters of U.S. citizens. Because there are yearly caps here, these categories often have waiting lists, shown in the visa bulletin, that can stretch for many years depending on the category and the applicant's country of origin. These are the categories that are sometimes mentioned in policy debates, especially F3 and F4, the married adult children and sibling categories. Yes, there have been discussions about reducing or even eliminating some of these preferences, often in the context of shifting toward a more skills-based immigration model. But again, those were discussions and proposals, not changes to the current law. As of now, these family preference categories still exist. People are still receiving green cards under them. The main challenge is wait times, not the category disappearing. Could family-based immigration change in the future? The honest answer is yes, it could. Immigration policy does evolve over time. It has in the past and it will in the future. However, major changes such as removing entire family categories, ending sibling or adult child sponsorship, or drastically redefining who qualifies as a family member would face significant legal challenges, major political resistance, and logistical hurdles within the existing immigration framework. It would require new laws from Congress, likely court challenges, and time for implementation. Even during the last administration, which took a hard line on many aspects of immigration, travel bans, asylum restrictions, attempts to end DACA, etc. The core structure of family-based immigration through I-130s remained in place. Why? Because it is deeply embedded in U.S. law, supported by a wide range of stakeholders, and central to how millions of people have legally immigrated to the United States. What does this mean for your I-130 or family case today? If you are in the process of filing an I-130, have already filed and are waiting, or are planning to file soon, here is the most important message. Nothing in current law has changed that would cancel your existing right to file or process a family-based petition. Right now, USCIS is still accepting and processing I-130 petitions. The immediate relative categories are still active. The family preference categories, F1, F2A, F2B, F3, F4, are still in effect. Wait times and backlogs may shift, but the fundamental ability of U.S. citizens and lawful permanent residents to sponsor certain relatives is still there. So if you are eligible today, your eligibility, process, and rights under the current family-based system remain unchanged. What should you do if you're worried about these rumors? Here are some practical steps. 1. Go to official sources. Don't rely solely on viral videos, screenshots, or WhatsApp forwards. Instead, check uscis.gov for official information on I-130 requirements. Forms processing updates. Look at the visa bulletin on travel.state.gov for family preference wait times. If USCIS hasn't posted it and congress.gov doesn't show a law being passed, it's not an official change. 2. Talk to a real immigration professional if needed. If your case is complicated or you're unsure what you're hearing, it's smart to consult a licensed immigration attorney or a BIA-accredited representative. They can review your specific situation, explain whether any proposed changes might affect you in the future, help you avoid mistakes in your filing. But remember, even the best lawyer cannot predict the future or promise to protect you from laws that haven't been written yet. Be very cautious of anyone who demands large fees, claims they can lock in your status against imaginary future laws, or pressures you with fear-based sales tactics. 3. Don't make big decisions based on panic. Do not withdraw your case. Rush into a different visa category, or spend money you don't have just because of a rumor that family petitions will end in 2026. In most situations, the safest and smartest thing you can do is to follow the current rules and keep your documentation clean and accurate. Take a breath, check the source, then act based on facts, not fear. The bigger picture, immigration is personal. For many of you, it's not just about papers and forms, it's about reuniting with loved ones, building a safer life, creating a future for your children, supporting aging parents. When you see alarming headlines about the very system you're relying on, of course you're going to worry. But here is the reality. The U.S. immigration system is complex, but it is not collapsing overnight. Family-based immigration remains one of its main foundations. The I-130 petition process is still functioning largely as it has for many years. Changes to immigration law almost always move slowly through. Debate legislation, public input, and court review. That means you usually have time to learn what's happening, understand your options, and make informed decisions. And in the meantime, you can rely on Immigration Updates Hub to bring you clear explanations, up-to-date information and context, without hype and without fear. If you found this explanation helpful, please consider subscribing to Immigration Updates Hub for more videos on U.S. immigration news policy, changes green card processes, visa updates, and everything you need to navigate the system with more confidence. Share this video with someone who is feeling anxious about their family-based immigration case or an I-130 they've filed or plan to file. Let's work together to spread facts, not fear. And if you have questions about your immigration journey, whether it's about the I-130, green cards, visas, or anything else, drop them in the comments below. We read them, and we're here to help you understand this system as clearly and calmly as possible. Thanks for watching, and take care.